Okay, it's 9 o'clock, so if everyone can get muted who needs to be, that'd be great. Good morning. Thanks everyone for coming for a special meeting. Hopefully it's not too long of a meeting, but I appreciate everyone coming. Kelsey, are you on here to take notes today?
Yes, Madam Chair, I'm here.
Okay, good, thank you. Let's see who else with us this morning. I'm Annette Lutz, Toledo. Tom Neal.
Here.
Okay, Frank Bergassa.
Here.
Doug Brusso. I knew Doug was here. He was on.
I'm here.
Okay, there he is.
Yeah, I'm here. I just was muted. Hang on.
Good morning, Doug.
Good morning, Annette. Good morning, everybody.
Scott Allen.
Good morning. I'm here.
Good morning. Jim Davis.
Good morning.
Good morning. Larry Danflus.
I'm here.
Good morning. Okay, all the reps are here. Let's see what alternates are here. Christopher Douglas.
I'm here. Good morning, everyone. Good morning.
Good morning. Dean Hamilton.
I'm here. Good morning.
Morning. We know John Canada is here. He's working and is muted. John Diacogiorgio.
Good morning. I'm here.
Good morning. What about Dave Bergassa? Okay, or Keith Trammell. Okay. What BSVI or Bureau staff are here today?
Christy House is here.
Okay, good morning, Christy.
Amy is here.
I heard Sally. Good morning. And then somebody else. Was it Amy?
Amy, yeah.
Okay, Sally and Amy. Good morning.
Greg is here.
Good morning, Greg.
Good morning.
Anybody else from OOD here? Yeah. Okay, let's see what operators we have. Anyone from Toledo?
Connie standing here. Good morning.
Good morning, Connie. Anyone else from Toledo? Okay, what about Cleveland? Okay, what about Akron Canton?
Ben Williamson.
Good morning, Ben.
I'm going to try to stick in here for as long as I can.
Okay. Welcome. What about Zanesville? We know Lisa Litzinger. Oh, good morning, Mark.
Pappas is here. How you doing?
Good. Anyone else from Zanesville? Hey, what about Columbus?
Julie Russell.
Morning, Julie.
Mark Wood.
Debbie and Mark. Okay.
Misty Straight.
Missy. Anyone else from Columbus? Okay, what about Dayton?
Olivia Lomas.
Morning, Olivia.
Good morning.
Okay, and what about Cincinnati?
Derek.
Morning, Derek. Okay. Anyone believe they got missed?
Annette, Ethan Gregory is here with the Ohio Attorney General's office.
I was just getting ready to ask for guests. Thank you, Ethan. Good morning. Anybody else? Any other guests then? Okay. I had one request for public comment, and that was from Derek Newfarth. So.
Annette, I'm gonna
I'm not going to make a public
Okay.
comment, except maybe to say and start the trend again of the Ohio Business Enterprise Program, the premier career opportunity for Ohioans who are blind, and the service provider of choice for its customers. And that, as many know, that's the vision statement that we adopted about a decade ago. And underneath that is the mission statement, which is the Randolph-Shepard Act. And its primary purpose, of course, is to generate remunerative employment toward the end of greater self-reliance for blind individuals. And I hope that as we get past all of the challenges of the last year, that we can get back to that mission and achieving the mission with the goal of our vision statement. So, other things that I might have wanted to comment on today, I think will come up through the meeting. So, thanks, everyone.
Hey, thanks, Derek. Did anyone else want to make a public comment? Okay. Well, we had 3 things on the agenda to deal with today. And like I said, I appreciate everybody making themselves available for a special meeting. We will do our regular meeting in 2 weeks, but we have 3 things that are a little more time sensitive to deal with today. First thing on the agenda was the ODOT contract and the payment of fees. I do know that a lot of operators got together, highway operators got together to discuss the agreement itself. Notes were taken during that call, and I have since given those to the Bureau. Thanks to Derek for taking the notes for us, and gave those to the Bureau. So that'll be part of their ammunition for going to ODOT if and when a new contract is negotiated. But we also wanted to discuss the janitorial and utility fees that are being paid right now. So would anyone like to start the discussion, or are there any motions that might need to be made we can entertain?
I have one, Madam Chair, if we want to start with that and then take the discussion from there, or would we like to do the discussion first? Either way.
Well, you can go ahead and make your motion.
Bear with me 1 second here so I can read. The motion is that that BSVI/BEP notify the Ohio Department of Transportation, ODOT in parentheses, that effective July 1st, 2021, we will no longer pay janitorial/utility fees at Ohio rest areas due to the following reasons. And I'm going to give John Kelsey, and depending on what happens with this, Kelsey, I will get you a copy verbatim of this. I will send this to you in email.
That'd be great. Thank you.
And those reasons are, the first bullet point is a decision by the Sixth Circuit Court in State of Ohio versus U.S. Department of Education. The second reason is Ohio 2014 Attorney General Opinion, in parentheses number 2014-008. And the third one is BSVI BEP current practices with BGA agreements at Ohio universities and the Department of Administrative Services, DAS in parentheses.
Okay, is there a second?
For the purpose of discussion, Madam Chair, I second.
Okay, thank you, Tom. All right, we will open the floor for
Can I
discussion.
start off the discussion?
Yes, absolutely.
I'd like to ask Frank to consider revising his motion because the language that's in there has been used in the past for the Bureau to dismiss our recommendation because we're directing the Bureau how to speak to one of their fellow agencies. And we've been told in the past that we don't have the authority to tell them how to interact with other people. So I think the language should be changed to say something along the lines of, we're recommending that the Bureau immediately stop the collection of what we feel to be the illegal janitorial fees. For us to tell the Bureau to tell ODOT something, I feel like the Bureau is going to come back and say, you can't tell us what to tell someone else. Also, I'm not sure why we picked the deadline of July 1st. If the feeling is that the fees are illegal, we should be going for June 1st. And with that, Madam Chair, I just wanted to help start the discussion, and I'll go with whatever other people think.
I get what you're saying. I kind of thought July 1st myself, but you're absolutely right. The fees are illegal, and they should be stopped as soon as humanly possible to stop them. So I did like the notion of giving ODOT a little bit of kind of notice on it, and maybe that's still necessary to do, but we do want them stopped as quickly as we can, because our folks shouldn't be continuing to pay fees that are illegal for them to pay.
Madam Chair.
Yes, John.
So I understand that the fees are illegal and I don't think we should be doing anything illegal, but I'm also concerned about the potential ramifications that this may have to our program in the future, and ODOT wanting to eventually work with alternate contractors because we are not providing them fees, and I just want to make sure that that is considered by everybody as well.
I think it has been. Right now, it would take a pretty significant change in federal law for ODOT to be able to do that. I honestly don't believe our measly little bit of money that ODOT receives from our program is going to change the way they would feel about any laws that would come their way. If the federal government changed the law, our measly little bit of money that they get as part of their big budget, that's significant amount of money to us. To ODOT, it's nothing. It's peanuts. It's petty cash at best in their multi-billion-dollar budget. So I can't imagine they would hold that against us. And I've kind of noted this as if there was a ruling that the Department of Taxation was collecting income taxes from people on something that was illegal, the state of Ohio would immediately stop doing that. So it's not a personal thing. It's a government. The government's collecting money it shouldn't be collecting.
Yeah, I mean, I see that, of course, too. And also, Madam Chair, the advantage to us is huge because we'd be getting a lot more maximum service charges by you guys not paying this janitorial fees as well. So I see both sides.
Yep.
Madam
Anybody
Chair,
else?
this is Dean.
Yes,
Madam Chair,
Dean.
this is Dean.
Yes,
I just
Dean.
wanted to bring up, and correct me if I'm wrong, but I don't think ODOT collects this so-called fee from anyone else, any safety brake operators, any other subcontractors that ODOT may use. It's just been isolated to us, and that's why I consider it not a fee. It's a commission.
I don't believe ODOT collects any kind of fees from their other subcontractors.
Right.
They could. I don't know everybody they subcontract with, but the other contractors who provide service, ODOT pays them. They don't collect fees from them. So we're obviously not asking to be paid. Our customers do that for us. But I don't believe ODOT collects fees from other subcontractors. There may be some out there they do that I'm not aware of.
Madam Chair, I will ask if other committee members, I know, I think it was Tom suggested we change this date. So I don't know if we want to change it from July 1st to effective immediately, or did Tom say June 1st? I'm just trying to find the right language here, not trying to cause a problem, but trying to get this dialed in as well as we can.
Madam Chair, this is Dean.
Yes, Dean.
And I just wanted to chime in that I agree with Tom. I mean, if it's illegal, why fool around? Make it June 1st.
Madam Chair,
Yes, John.
there are ramifications such as having to deal with the reporting systems that are gonna need to be made changes to. So, if for those reasons, you may want to wait till July 1st.
Well, if we did it as soon, immediately, as soon as possible, I mean, that the Bureau can, we're already paying for April. That goes to May 24th. People's already, filling those in for collections for April. So the Bureau would have plenty of time to adjust anything on their on the OBG.
Well, Madam Chair, if we say effective June 1st, these fees no longer be collected, then the Bureau would have until June 24th to get the automated system changed, because the last fees that would be paid would be the month of May.
Yes.
And I'm fine with changing the date. We need to change that date to June 1st. I have no issue with it.
As do I. So. Okay. So yes. Who is that?
Derek.
Derek. Okay.
I agree with making the change, but I would strongly urge that you not make it a date, that you make it immediately, or some phrase like that. It shouldn't be a hard date. It should be immediately, I think. But food for thought.
Well, immediately it raises some issues because some people have done their reports already for April. Some haven't.
Derek?
Yes, Derek.
Well, it seems like by setting a date, you're trying to solve problems that aren't at issue in the motion. The motion is to get these stopped. It doesn't, and it's up to the Bureau if they accept the motion to find a way to do that in the way that we suggest. And the way we're suggesting is that you stop doing it. And whatever way they can find to make that happen is up to them. I mean, we can give them advice or recommendations as to the best way to do that, but let them figure that out, because we could end up with a less effective motion by trying to do all of those permutations ourselves, is my point about saying stop doing it. I mean, I kind of agree with Tom that the motion should be stop collecting janitorial fees, period. That touches everything that needs to be touched in the motion, but I understand the need for additional things, but setting parameters I don't think is a good idea. That should be up to the Bureau. They're the ones that has to do the thing, so they should be able to, they shouldn't be being told how to do it. I think you made the point actually earlier in that. Anyway, it doesn't matter. It's neither here nor there. I mean, I suppose I'm making a philosophical argument, but anyway.
No, that's good.
Madam Chair, may I?
Yes, Tom.
I think Derek's point does matter, and it does matter because if it's illegal, we should never, if we believe it's illegal, we shouldn't allow an illegal activity to continue for one more moment. However, in the interest of trying to be aware of the logistics involved and the the need for the Bureau to give an opinion, I felt that saying June 1st gave them, it was a reasonable suggestion. It gave them plenty of time to make the changes if they were interested in making the changes. And to say immediately, I was concerned that we would get the response, well, it can't be done immediately, therefore we're not going to do it. So I was trying to be a little bit more, I guess, generous with the suggestion, but Derek has a good point. If it's illegal today. So I guess, and also with the language again, I don't know that I can vote for this motion in its current configuration. I think the language needs to be changed from us suggesting that the Bureau tell ODOT anything to something along the lines of, we move that the committee, we move that the Bureau immediately stop the illegal collection of janitorial fees from rest area operators, and leave it at that.
And janitor and utility fees. We want to make sure that's in there too because of the secondary.
Okay, yeah. Now, Frank has a motion out there that needs to be voted on. I'm not making a motion right now, Kelsey. I'm just offering a suggestion to people to help craft one, or for Frank to amend his if he's so interested.
Yeah, we can change the language. We can change it to what you just said, Tom. And then, do we want to go with effective immediately, or I'm just trying to get the wording down here. This needs to be on, you know what I mean? Needs to be good so that the Bureau has a good motion, the committee has a good motion. So that, let's see,
yes.
That BSC.
Who was that chimed in?
Oh, Larry.
That was Larry.
Oh, Larry. Okay, sorry, Larry. Go ahead.
Oh, hey, I just wanted to bring something up. If this thing goes through, and then months down the road, it turns back that you guys still have to pay these fees, I would just make sure that people keep money set aside, because there might be a backlash on people. If it doesn't, I hear the word illegal going around a lot, but we're not the deciding factor, you know.
Madam Chair.
Madam.
Go ahead, Tom.
I just wanted to say that I clarified in the beginning, we believe it's illegal. We are not legal people. We do not have an opinion on this. And to anyone listening, any rest area operator, anyone who plans to communicate to a rest area operator, the committee's motion is not a binding thing. Do not stop paying janitorial fees until the Bureau gives a response.
Absolutely. And I will go one step further, though. It's not our belief. This is what has been ordered by a federal judge in the 6th Court of Appeals. So it's not any one of our opinions on this. This has been ordered. It's already been found illegal. Now, there are some varying opinions as to whether the order includes such fees as janitorial fees and utilities, as opposed to, say, just commissions. But the thought is, honestly, if the state of Ohio is collecting money illegally, and there's even a small chance that the state of Ohio is collecting money illegally, which I would suggest this ruling definitely suggests that there's a pretty darn good chance that it's happening. The state of Ohio should stop doing that. This is a government entity that should not be in the business of collecting cash that is illegal to do so.
Madam Chair, I know there was someone in front of me, but can I have it again when they're finished?
Yes, I think Frank was.
Oh, I was going to say that we're not, you know, the committee, we're not the determining factor to whether or not these are illegal. This has already been determined by the 6th Circuit Court in their ruling or decision, whatever you want to call it, that they're deemed illegal. That's not the committee's purview or decision to determine if we're basing our motion off of something that has been through the court system and been decided, I guess is what I was trying to say. Thank you.
Go ahead, Tom.
Madam Chair, just for the purposes of any future anything, our meetings in the past have been used against us in hearings and such. So I wanted to take a moment and clarify my earlier statement when I used the word "our belief." When we read the language, we feel that that language says these fees are illegal. When the Bureau reads the language, they feel that these fees are not talked about in the language. Therefore, I use the word "our belief" because until we have a legal opinion on the subject, we are two people with two different views of the same legal opinion. Therefore, until we have something that's more binding than just our reading of it, I use the term belief. But I believe, again, I'm using that word, but my feeling is that anyone who reads that language would say the collection of this fee by the Business Enterprise Program from blind operators for transmission to ODOT is clearly illegal under the Sixth Circuit and under the 2014 decision. And I want to make it clear, if we ever have to go any further with this in the future, the word belief doesn't mean I disagree with this. I completely think this is illegal. But again, I think because I don't have something that specifically refers to janitorial fees. And Madam Chair, I think that clears it up as much as I need to.
Thanks, Tom.
Madam Chair?
Yes, Doug.
Yes, I just want to say that I'm listening to this conversation, and we are kicking around legal and court opinion and all that. Well, we have a legal representative for the committee who has not chimed in at all in this conversation. I'd like to know what Ethan has to say about this.
Well, the only thing I'll say is, and Ethan, forgive me if you're wrong, if you're not prepared to say, or you are prepared to say anything. I don't know if Ethan has read the.
No, I don't either. If he hasn't and he has an opinion, I'd like to hear that.
Annette, I have not read
okay.
the Sixth Circuit opinion or the AG opinion from 2014. I haven't looked at either of those. Neither of them have been provided to me, so I wouldn't be able to really give an opinion on those items.
Okay.
Madam Chair?
Yes, Doug.
I respect to you, Ethan. I think it's you represent us, the OVRC, and yet the Bureau has not found it necessary to provide you with the court opinion or the subsequent documentation around this.
Madam Chair,
that's really not fair to us, is it?
Go ahead, Tom. Yes, please.
I want to accept responsibility for this, Doug. It's not the Bureau's responsibility to transmit that stuff to Ethan. It's ours as a committee, and it's mine as the vice chair and as a member of the committee. I should have done that. I just assumed, and I wrongly, and I shouldn't have. And I will make sure that that stuff is transmitted to him today. But I do not believe it was the Bureau's responsibility to do so.
Tom, I would agree with that. I would agree with that, Tom. Thank you.
Yes, Tom, you're being very gracious, but to take that responsibility yourself. But I hold even higher guilt over that. So I should have
Madam Chair,
yeah.
If I may say, first of all, Tom is very brave for taking this responsibility on. I did not know as a committee member that it was our responsibility to provide Ethan with that kind of documentation. I was unaware, so I apologize to you, Ethan. I was unaware of these facts as a committee member.
Okay, well, we know now. We'll make sure it gets to him. So.
Yes, because I still want to know what Ethan has to say about this.
Yeah, I understand. We'll
Madam
get
Chair,
that.
Why don't we get the stuff to Ethan, give him some time to look at it, and maybe if he's available, come to our next meeting and give us his opinion at that time if he so chooses.
Now, will we have decided upon this relatively soon?
I'll be honest with you. I would like this, if it is the committee's the committee's judgment to pass a motion today. I don't see there being any problem with that. It is I mean, this thing is clear about, I still stick with what I said. If there's any chance, even if attorneys on the Bureau side, even if Ethan says honestly that they disagree that janitorial fees aren't included, there is a very strong possibility that they should be included in this and are included in this thing. I mean, it does use the word commission, but it also uses funds and monies and words like that collected from vendors for purposes other than what the law requires set aside money to be used for. And
I agree with you in that. I'm not trying to argue with that at all. I'm just what I'm trying to do is to make sure that the committee has all the facts, and we have this weapon in terms of Ethan, and because we can get the documentation to him, I feel like we haven't utilized our weapon. Does that make sense?
Right.
You know, and that's all I'm saying. I mean, I have a plan for this motion, and I have a vote for this motion, and I think you'll be pleased with what I'm going to vote, and that's pretty much it. I apologize to those people.
No need to apologize, Doug. It was a valid question, so we will get that out there, and I'm still under the belief, even if there is only a 1% chance that these fees are being collected illegally, they should stop. The state of Ohio should never be in the practice of taking the chance of collecting money from its citizens. That's against the law. So, and I believe it's way, 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 way higher than 1%. So.
Madam Chair, I was going to offer some
Frank.
alternative language and see if Tom and the other committees would be okay with this, and that is, it would read like this, that the SEIBEP immediately stop the unlawful collection of janitorial and utility fees at Ohio rest areas due to the following reasons, and all the reasons I had listed earlier, if everybody would be comfortable with that.
You putting that out as an amendment?
Yeah, we can do that.
Okay, yeah. Tom, are you happy to second that amended motion? Okay. So, and once again, Kelsey, we'll make sure you get the exact language.
Madam Chair, I'm going to throw the comment in there, though. We're putting a whole bunch of other language at the end of it. I think simple is better, and we don't need to give them the reasons why. They know, they're aware of those court opinions. They're aware of the law. We don't need to lay it out for them. But
the only thing I'll disagree with that, I'm sorry, Tom, I thought you were done. The only reason I would disagree with that is that we would have to assume that the Bureau would share this motion with ODOT. So it's probably good to share what our reasonings are with ODOT.
Madam Chair, I believe the concern I'm trying to express, and my apologies, I'm apparently not firing on all cylinders this morning, but if we put specific language in there and we omit something, then we can, because we omitted that thing, if that helps us even more, it cannot be considered. Since we got specific, if we weren't specific enough, we just harmed ourselves. Because by naming these very specific things, we're excluding other things that may also be beneficial to us.
Madam Chair.
Yes, John.
So the motion says that it's because of the Sixth Circuit Court decision, and that's the major reason that we're doing it. So we're really covering ourselves by doing that, saying that in there.
Okay. Any other discussion?
You know, I always have a little more.
Okay.
We've all seen arbitration decisions in the past where things have been rejected or people have lost their dispute because of the language that they put in their filing. And if they omitted something in their filing, only the language that was included in the filing was used to make the determination of whether or not it was permissible. So again, that's why I say for us to put specific language in here, we're then omitting anything else that may be helpful to us that we're not aware of at this moment in time. And that could potentially be harmful to us in the future.
I just don't know, omitting all of it helps us, I guess, at that point. I don't know.
Yeah, Madam Chair, the only thing I will say is I believe the reason those reasons are, I have them in there because I believe they strengthen not only it gives the reasons for the motions, it shows that the motion isn't just, hey, we just don't want to pay this anymore. We're doing this for a couple of legal reasons, the two legal reasons, the Sixth Circuit Court decision, then the Ohio 2014 Attorney General opinion, and the current practices where our program, the SBI and BEP, have already had to adjust at other state agencies such as universities and at DAS. And I'll reiterate, this Sixth Circuit Court decision says, as you explained a little while ago, that basically that the funds can't be used for, they can't collect anything other than is what is necessary for service charge or set aside, however you want to use that language. Those 5 things listed in, the law that service charge or set aside can be dispersed for. So that's essentially what it says in a more technical form, and I don't want to get into all that to bog the meeting down, but I was just putting it out there. And I was also trying to, like I said, strengthen the motion in case we would end up, God forbid, in some kind of grievance dispute over this whole situation, so that we do have some strength to why we did it and how we did it and what our reasoning was. Anyway, thank you. Sorry.
Okay. Any other discussion? All right, then we will call for the vote. Everybody knows the motion.
I guess, Madam Chair, before we vote, can we have it read back to us, please?
Yes.
What?
Frank?
Yeah, let's see. Immediately stop the unlawful collection of janitorial and utility fees at Ohio rest areas. And then for the reasons that I had listed earlier, do we need to go through those again?
Yeah, read yeah.
Decision.
Madam Chair, I'd like to hear the motion exactly as being presented to the Bureau, Frank.
Oh, you want the Bureau to read it?
No. He wants you to read it as it'll be presented.
Oh, okay. That's what I'm trying to do, Tom. Immediately stop the unlawful collection of janitorial and utility fees at Ohio rest areas due to the following reasons. Decision by the Sixth Circuit Court in State of Ohio versus U.S. Department of Education, Ohio 2014 Attorney General opinion, in parentheses number 2014-008, and BSVI BEP current practices with VGA agreements at Ohio universities and the Department of Administrative Services, DAS in parentheses.
Okay. We'll call for the vote. Frank?
Yes.
Tom?
No.
Larry?
Yes.
Jim? Did we lose Jim? All right, Scott?
Jim is here.
Yes.
Oh, Jim?
Yeah.
Yes, okay. Scott?
Yes.
Doug?
Yes.
Okay. Motion passes. Any more discussion about ODOT and the agreement or fees or anything along those lines?
Madam Chair, I know there was a
Yes.
list of concerns sent to the program from that call, and I guess my question is, and I don't know if they've spoken with you and Tom about this, do they plan on taking those concerns or going back as they work on a new contract with them, or trying to address these through that or through other means, or where they plan to, I guess, take those concerns, or how do they plan to try and resolve them or negotiate them, whatever the term may be?
Madam Chair, it's Greg.
Yes, Greg.
So yes, so what we'll do is incorporate what you guys had presented to us in putting our stamp, so to speak, on the BGA, and incorporating the thoughts and your ideas on there. We may need to follow up if there's some clarification, so that we have something to send back. However, I think even before that happens, with the motion being passed, Director Miller will be talking with Director Marchbanks also about the fees. So it's a process. We don't actually sit down in a room and haggle back and forth like. But we will draft the language. We will redline what we don't like that they put. We will add our additions and send that back to them once we incorporate those. We can, once we come up with the language, we can also share it with the committee to make sure that we're hitting it and that we're on the same page about what you guys were saying. And if there's something that we can't come up with, or I didn't see anything on there at first glance, but if there's something that we're not sure that we want to include, we will get back together with you guys as well. But the process really is us now incorporating your feedback in our proposed draft back to ODOT.
Okay. Thank you. Anyone else have anything on ODOT?
Madam Chair, I have two, and I'm not sure, Derek had called and asked me about the notes, and I had mentioned a couple of things to him after the fact, and when he had called and asked me, I couldn't remember what they were, and then a few days later I did. There were a couple of things in there that I believe it said something about following all security procedures at ODOT facilities, and my thought was, what are security procedures at a rest area? And the other thing in there was that the vendor will be readily identifiable, and I'm like, I don't know what that means. Are they trying to say we need to wear a uniform or something along those? I sure hope not, but so I don't know where they were going with that, but I just wanted to throw those couple of things out there for consideration to try and figure out exactly what they were meaning, or why it was in the contract like that.
Yeah, those are kind of vague languages. Greg or Christy, can you add those to the list?
Madam Chair, sure.
Okay, because yeah, that is kind of vague. Regular identifiable. It's probably the blind guy who has their head stuck in the vending machine, but that might not be what they're referring to.
Yeah, and Madam Chair, I'll add one more thing, that I have had some operators, and I think that may be listed in those concerns, that the ODOT agreement should be as simple as the DAS agreement. So, and that's some feedback I've heard. But I think that may be listed in those notes anyway. But I was just throwing it out there in case it wasn't. But I believe it is.
Absolutely. Yep. And that was on the list.
Yeah, I thought it was.
There's no need for the contract to be quite so long and so encompassing of so many things. I mean, it honestly should say we provide service at the rest stops. They provide the stuff we need to do the service. There you go. All right. Moving on, we're going to do we have the rules on here, but I'm going to jump and do the Sandusky Veterans Home. First, this has come up just this week. I'm going to let Christy kind of present what's going on with this, and then we can talk about some of the history and ramifications and pros and cons.
Yeah,
Christy?
Madam Chair. So this came up summer of 2015, and I remember this because I was just coming on board. In the Ohio, it's Sandusky Veterans Home. It's not the VA clinic, it's a veterans home. And we had done an assessment there, and then they pushed back on us, stating that there is a competing law that states that they can take the profits from commissions of doing vending for their residents fund, for their clientele fund, and that's how they have money to do things for their residents. And you guys pushed back on that, and then we went back to them, and they said, listen, we're going to fight this. We'll open up the law, change the law. So we went back and forth and we talked about it, and you guys gave a waiver. You know, again, the other thing is, and I don't know what their sales are back then, what they are necessarily right now. I think with COVID, you know, just like even it's a residential place. I don't know, you know, even getting last year's if there is any sales. I know, like, again, Elton Prison, they stopped vending. But, you know, they've come back to us. The waiver is about to expire. I think they're trying to renegotiate. You know, I talked to Annette about it. I know she's talked to Lynn too. It's in Sandusky. We don't have many people near or around the Sandusky area. I don't know, and Greg might be able to talk. I know that we used to have an embedded counselor in that area, but we've even pulled that out even before the pandemic. Again, so the question is we can fight to get in there. They're going to fight back, but we can. We don't know necessarily if it's a good business. And the most importantly is I don't know if we have anyone interested, and that's a concern too.
Derek?
Madam Chair.
Derek, go ahead. Frank.
Well, I mean, Frank's a member. Let him go first. I'll go after that.
Okay. Go ahead, Frank.
Madam Chair, just for purposes of discussion, can we find out what law, and I know we've had this discussion before, Christy. I remember this from 5 years ago or so. And I did talk to Annette about it on Wednesday. And I off the top of my head, I don't know what law they were citing or what law, but could we find out the exact law? Just and I don't know if you have it or not, or maybe Ethan may know, or if we can find out what law they're citing. I was just interested in knowing what it was. The other thing is, I think I would like to know what the at least pre-pandemic, what the sales of that place were, and I don't remember what they were for 5 years ago. It's been a little too long. And then what percentage of commission is being paid there? And the only reason why I ask is I know we can't pay commission, but I was just curious as to if it was like 30 or 40%, it wouldn't, you know, unless the sales were something dramatic, it wouldn't make a, depending on the percent of commission, it may not make a good store anyway. So, and we can't pay them anyway. And then the other question for Ethan I had, I guess from a legal perspective, is what happens when a state has two conflicting laws like that typically? And that sounds like that could be astronomically complicated. But so anyway, I had more questions than I did answers, but I think we need see if we can't get some of that information to.
Sure, Madam Chair. The law, the competing law is ORC 5907.11, and I'm trying to pull that up. It's email abyss. And we can go back and we can ask them what their sales are and what their commissions are. Again, we can't pay commission at all.
I know that.
So, but and I've
Christy,
got the law right now. I've got the 5907 Residence Benefits Fund. The superintendent of the Ohio Veterans Homes, with the approval of the director of the Veterans Services, may establish a local fund for each veteran's home to be used for the entertainment and welfare of the residents of the home. Each fund shall be designated as the Residence Benefit Fund and shall be operated for the exclusive benefit of the residents of the associated home. Each fund shall receive all revenue from the sale of commissary items at the associated home and shall receive monies received as donations by the associated home from any source. The superintendent, subject to the approval of the director, shall establish the rules for the operation of the Residence Benefits Fund. But you know, again, we can go and we can ask for information and all that. You know, again, if we're going to fight some entity, which we're willing to do, we want to make sure that we actually have an operator wanting to travel and to do this.
Madam Chair, to Christy.
Yes.
Christy, I'm not saying we're going to fight. I'm just trying to get some information because we may not want to. I believe you said this law was 5907.11. That's what I put down. And thank you for reading it. I appreciate it. No, I was just trying to make sure we had all the information, Christy. That's all I was trying to do so that we as a committee can make a very, very informed decision and an educated decision. That's all I was driving at. I don't know exactly what we should do here. I would like to, with the chair's permission, ask Ethan Gregory how cases like that are typically, or not a case, but how situations like that are typically handled when you have two laws in state statutes that conflict. You know, our law says we can't pay commission, and then their law says, well, if you're here, you have to.
Yeah, even go ahead.
Yeah, no. I mean, when it comes to conflicting law like that, I understand that the commission's law says that they can't pay commissions, and I'm looking at 5907.11 right now, and seeing that it does say that you have to pay commissions there. I mean, that may be something in this situation, since you guys are in talks with this facility to possibly enter into an agreement to provide services, that may be something that could be agreed to in the BGA, of you not having to pay those commissions. I mean, the problem is, I agree there's conflicting language in each law. It just kind of depends on how that would come out. I mean, we would want to get, if it came down to an issue where they say you have to pay, you guys say that you don't, that would have to be up to a court to decide what the difference is with that conflicting language, unfortunately.
Right, and I don't know.
I know it's not the greatest answer and promotes that much clarity for you guys, but unfortunately that it kind of comes down to the specific situation, and I can't give you a definitive answer on how that would exactly be resolved.
Okay.
Well,
Derek, I know you had something too.
Yeah, I'm sorry.
No, that's okay,
No,
Frank. You have very good questions.
Yeah, Frank asked a lot of good questions, and I think it's important, like he said, to make sure that committee, before it makes any recommendation regarding this, that it have all the information. And I would advise, based on the previous discussion, not to go too deep down the rabbit hole of what the law says and whether it conflicts or not and all that. I think it's more important to have the practical issues settled before you make any kind of recommendation. Not that shouldn't play into it, because if it's a losing case and we can easily see that, it'd be a crapshoot whether you'd win in a arbitration or whatever, or in a 119 hearing, then maybe you do want to avoid it. But I would settle the other stuff first. And the question that I wanted to ask is this an isolated facility? Is there only one of these homes in the state of Ohio, or is there a whole network of these homes that are state operated for which we would have priority? And if, well, I'll leave it at that. And based on that answer, I may have more questions.
Madam Chair, this is the only one I'm aware of. Like, again, the VA, like, VA facilities are different from a VA home, and I don't know of any other VA home.
Dirk was pointing out a string of VA homes.
Yeah, we don't know. Well, and it's not even the VA, because this is state property, not federal, from what I understand. It's state law, and the state of Ohio runs this, so the VA would be federal property. So I don't even know that they're related at all. But I don't know of any other ones. If there are other ones, they sure haven't come to us, you know, requesting a waiver or anything like that. That's for sure.
Derek?
Madam Chair. Oh.
Yes, Derek.
Well, yeah, I mean, I think that's an answer that I think that question needs to be answered, whether there is a network of these things that fall under the Mini Randolph-Shepard Act or not. Because that's important. If there's 10 or 12 or any number of these things out there, this becomes a much more important question. If it's just one isolated place and that's the only one in the state of Ohio that falls under the Mini Randolph-Shepard Act, then, you know, that changes the discussion quite a bit. So I think you should find that out.
Madam Chair?
Yes.
There's two. There's one in Georgetown in Brown County and the Sandusky one.
Okay.
I just
Frank,
did a Google search. So.
Google search?
Yeah.
Madam Chair?
Hold on, I think Frank.
Sure.
Yeah.
For you, Doug.
The question I had, Madam Chair, is when do we, if we decide, does Christie have a deadline for this waiver, or the program have a deadline that they need to have this waiver by, and when is it?
Madam Chair, they've asked me last week and this week, so I'll call them on Monday. I'll find out the information that you guys are requesting. Then I can get back to you guys by the 21st, and I'll tell them that we'll have an answer after the 21st meeting.
Sounds good. We get one more information and you can do a little more research then. Okay. Did anyone have anything more? Or
yes, Madam Chair.
More information? I'm sorry. Yes, Doug.
Yes. My concern regarding this discussion is a little more wide range, and it kind of ties into what Frank and Derek are saying. My concern is these two laws that are conflicting. Is there any consideration for the fact that these two laws could apply to another one of our locations that has stronger sales and operators that do want to work it and it is profitable, but this could, you know, these two laws could drive the Bureau and the OVRC into major court battles and like that?
I would say that the law that's conflicting is very specific to the veterans' homes.
I see.
So
that answers the question.
Yeah.
Thank you.
Okay. Anyone else have anything about that? Okay. Then we're going to get into the rules. We have Rule 12 specifically that is still out there with some different language we wanted to talk about. Before we get into that, though, the Bureau sent out a list of small kind of clerical and grammatical and clarification changes to the rules where a few words would be changed here and there. I hope everyone had a chance to look at those. And if anyone had any concerns about any of them. I do have a concern about one of them. That I will bring up, and then if anyone has anything else they'd like to bring up about that list, and then I know there was a couple other questions people had about rules too. So Christy and Greg, the one I'm going to bring up is in Rule 13 in your list of clarifications and questions and changes. You wanted to change the word activity to offense, referring to a criminal offense. And I have to disagree fairly strongly with that. Right now we have a definition for what criminal activity is. It only constitutes certain laws. In Rule 13, if you put the words offense there, that someone's license could be revoked or suspended due to conviction of a criminal offense. Technically, that could be jaywalking, because we have no definition for what a criminal offense is, so it could be any criminal offense. So I don't think that's a good change.
Madam Chair, it's Greg.
Yes, Greg.
Okay, I see what you're saying there. I think the thought was activities, not really. It was being looked at from a legal perspective, like that. Somebody can claim anybody's up to criminal activity, but it's actually charged with an offense, so that there's actually something there. But I see what you're saying. We can take, as we said, if there's anywhere you guys are uncomfortable with, we can take that back. And, I see your side of it too with what you're saying there. So, I don't know if Christy, if I'm speaking out of turn, or if there was something else, but,
No, I agree.
Okay.
That was myself, the only one that really jumped at me as a problem on that specific list. Did anyone else catch anything or?
Wait, okay.
Derek?
Okay. Yes, Derek.
Was Rule 13 the only place that term occurs and was suggested to be changed?
I believe so. Criminal activity does come up in other places too.
Unmuted or don't you know?
You are unmuted. We can hear you, Doug.
Thank you.
I know criminal activity shows up in other areas when it talks about,
That's what I'm asking. Why would they, if the term criminal activity shows up other places than Rule 13, why did they only want to change it in Rule 13 and not the other places it showed up?
Oh. Don't know, but either, yeah.
Yeah, I was just curious, because if it was just the one place, then change the definition of criminal activity to criminal offense, because what they said about the difference between activity and offense makes sense. But if there's a reason, and there might be a reason other than they overlooked the other occasion, the other occurrences of it, but there also could be the possibility that they wanted to draw a distinction in that rule in particular. So, since nobody has an answer, maybe it doesn't matter.
Yeah, and if it is a big deal legally, one suggestion would be you could keep it as criminal offense, but then word it back to the definition,
right?
And say, a criminal offense included in the list of criminal activity as defined in, the definitions or something. That way it would gear it towards those very bad things that are in the definition that we all agreed to. So, okay. Any other thoughts about the changes?
Yes, Madam Chair.
Yes, Doug.
I have a simple thought for you, since you're the rep in Toledo. The Rule 12 changes the election date from even to odd years. Are you aware of that?
Yes.
Okay, that's not a problem for you?
We did that when we were talking about, which that's one thing we still got to talk about, when it was on the table to go to 8 districts as opposed to 7. And then we had moved Toledo so that there would be 4 and 4.
Gotcha.
That's one thing. When we get to Rule 12, the committee has to decide one way or the other how we want to go with that. But if we keep it at 7, there's no need to move the election time for the Toledo district.
Understood. Thank you, Madam Chair.
Mm-hmm. But we'll hit Rule 12 here shortly. Okay, so if there's no more concerns about the list of proposed clarifications and grammatical
Chair,
and
this is
legal
Kelsey.
changes. Yes, Kelsey.
Just for minutes purposes, I didn't quite catch, were we keeping activity or were we keeping it as offense?
Greg said that they would take it back, and I don't think he, Greg,
So,
you want to?
Madam Chair,
Yeah.
Madam Chair, it's Christie. So the only concern is, and again, I think it is a lawyer term. It's a legal thing in the sense that activity, I understand what you guys are saying, but an offense would be something that is met by the definition of a crime, And I don't know what a criminal activity is compared against. That's the question. So it is a crime. It's not like jaywalking or something like that. And you made something that I think that we could maybe strengthen the language that maybe criminal offense of a crime. Maybe if we just add that, like that language of a crime, and to put that in, where would that clarify that and help?
No, because I don't know. I mean, by no means am I an attorney, but just from my thoughts, jaywalking is a crime. It's a very low, tiny level one, but it's still a crime. And if there's signs that say don't do it, and you can get a fine for it or get a ticket wrote for it or something, it's a crime.
But then what?
Madam Chair.
Isn't that activity too?
Well, we have a definition for activity. Criminal activity is not a legal term. It's a definition in our rules that lists specific items that we all, as a group, have all determined are sufficient enough to warrant causing problems in the program. Somebody who was found guilty or something for one of those offenses.
Okay.
Madam Chair.
Yes, Greg.
It's Greg. I'm going to make this simple. We will take that change back to the original language. Okay. It's fine. Not a problem.
Sounds good. There you go, Kelsey. Thank you,
Thank
Greg.
you.
Okay. So then let's talk about Rule 12. Everybody saw there's a couple things we need to talk about in Rule 12. Everybody saw the latest draft. It holds the language for what to do if there is a vacant, unfilled position. And most of it looked pretty good. I know a couple of you brought up different things. The idea, and I think, Derek, I know you had a couple ideas on it about some language.
Do you want to address the simpler one before we get to that? Of the Toledo voting time frame?
No, well, we got to talk about whether we want 8 or 7 districts in there first, I guess. But we can hit this thing about the vacant thing first.
I didn't realize anybody was going to raise an issue of whether it should be 7 or 8. I thought that was a settled issue, but yeah, you should talk about that too then before you talk about whether Toledo is odd or even numbered.
Right. That's it. That's exactly right. That's why I said it's not as simple as we thought. But the vacant positions, the plan is pretty good. It was written out pretty good. The only concern was, I think, Derek, forgive me if I'm wrong, there was a notion of having to have somebody to hold a special meeting, not only if there's a vacancy, but if somebody requests one for a special meeting. And the thought was kind of the way the language is written in, well, if there's no request for one, there's always a vacancy. So what, do you hold a meeting every week, or, until somebody gets tired of seeing the how do you handle that? There should be some kind of clarification of, if somebody requests, even if they're from outside the area, after that first meeting, the request is what would trigger the special meeting. A second.
Madam Chair.
Yes.
That is true. That is one of the things I brought up about. The other thing is in Rule 12D, capital D, it says special elections to fill a vacant unexpired term of a representative or an alternate shall be conducted in the following manner. And I have no objection to anything that follows that talks about how you conduct the special election. But what I do think needs to be clarified is the term to fill a vacant unexpired term doesn't seem to address the issue of, if there's a regular election and nomination call for a regular election and nobody is nominated, then that doesn't trigger a special election. I mean, this current language that I'm reading doesn't seem to trigger a special election. So what I would suggest is that you add up above, where you're describing how a regular election occurs, that if a regular election nomination meeting does not yield a nominee, then anybody can request a special election nomination call to be held. Not anyone, any operator can. Not anyone, certainly not, but not any operator. The same as it says, it also says if during the term the representative resigns or whatever, leaves their post, then the alternate takes over, and then there needs to be a special election to fill the vacancy of the alternate seat. And that's the way it should also be with the nomination call of a regular election. If nobody's nominated, then there should be the ability for an operator to request a special meeting nomination call so that the seat could be occupied. Unless I'm reading D wrong, maybe I'm reading it entirely wrong, but it seems to me that you have to dig really deep into that language to get to a simpler way of saying what I'm saying.
Christy, are you following that?
Not really.
No.
Again, we've gone through this, and again, we don't care. We just want it to be clear. And I think the problem is right now is this is not clear. It's not clear at all. And I understand what the intention is that you guys would like to be able to, so an area does not go covered, that there's availability for someone else to serve in it. And again, I will go back to the easiest way to do that is to put that in the hands of the committee, of OVRC, whether it's the chair, OVRC, that someone like any other committee with vacancies right now, there is an appointment. Someone, comes forward that they're automatically appointed, or if or someone is chosen to fill the vacancy, that there is not, I really truly believe that, to make these nominations mean something, people need to come to the plate initially. And if they don't, then I think it should be up to the committee to appoint someone for the rest of that term. That giving people 2-3 times at special elections because they didn't choose to run to begin with, that people need to step up and run initially. That's my honest opinion. Now, with that being said, I don't care as long as we have a very clear rule. And to Derek's point, it is confusing. The reiterations of these have been very confusing. That it needs to be very clear so there's not problems. And I don't know how to make that.
Derek?
Go ahead, Derek.
It can simply be fixed. My only objection was that D states special elections to fill a vacant unexpired term of a representative or an alternate shall be conducted in the following manner. All you need to do is in D state that special elections are triggered by two events: the vacancy of one of the seats, representative or alternate, or nobody's nominated in a regular election nomination poll. That's it. And you can either put that somewhere in D, or you can put that in the language above that describes the regular election. But those are the only things that trigger special elections, and that gets away from the idea that some of the committee members objected to of anybody appointing anybody. It needs to be left, no matter who's going to be there, it needs to be left in the hands of the people who elect who's going to represent them. And I don't disagree with that. And I think that, I don't know who wrote this, by the way, they did a very good job. They really did do a good job. But that one term just needs to be changed to make it clear that what they're suggesting applies to both situations, either the vacancy of a seat or nobody's nominated for the election that occurs biannually.
So let's hold on. So D, if I were to write special elections are triggered, can I put it right in here in D?
Yeah.
Triggered. It's one of two ways. One, okay, help me out, Derek. One to fill a, what did you say?
One is a representative or alternate seat is vacated for whatever reason.
Seat is vacated, okay.
Or a representative or alternate isn't elected through the normal regular election. I lost my terms there, I'm sorry, but you know, if nobody's nominated at a regular nomination call, that triggers a special election.
No.
And I mean, if the committee agrees with that language, I'd be more than happy to clean it up. Or I'm sure Christy, you or your people could clean it up because I didn't make that right then just very clear. But it could be made clear. I hope everybody understands the concept at least.
Yeah. Does anyone have any thoughts with that or any concerns with what?
So, Madam Chair,
Can I repeat what we have written right now?
Yeah.
I have special elections are triggered in one of two ways. One, a representative or alternate seat is vacated, or two, a representative or alternate is not nominated in a regular election nomination meeting. The special election shall be conducted in the following manner, and then you go into the steps.
Derek?
Yes.
And then you get into what you were talking about earlier, Annette, where as if there is a reason to have a special election, it's not that the Bureau has to schedule one every time there's a need for one. It's that somebody needs to, that an operator has to request it. And that's what triggers it to actually take place. There's a reason that allows it to take place, and then there's a cause that it does take place. An operator has to request it. Because it'd be silly to have a nomination meeting for a special election if nobody was interested anyway. You'd sit on the phone by yourself and nothing would happen. And so in order to go through the process of having the special election, there has to be an operator who wants it to happen anyway. Otherwise, there's no point.
So I think we can solve that. Instead of it saying special elections are triggered, maybe put special elections could be triggered in one of two ways. Could be. Instead of are, could be. So then, you know, that gives us room that it doesn't have to be. Does that mean it's one of these two ways if it's requested? Could be triggered.
Well,
Yeah,
yeah, I don't like that because that also takes it the other side of it could not be too. There's
What
some
about
kind of decision.
maybe triggered? Maybe triggered?
Madam Chair?
Yes, Larry.
If only one person is stepping up, is there a reason for an election in the first place?
Well, yeah, they would be elected by acclamation, but there's got to be a nominating call.
Oh, okay.
Which needs to be public, and other people have to have a chance to run if they so choose. I was trying to figure out this language, Madam Chair, and I was the special elections would happen upon request by an operator in that electoral district, or I don't know. We're trying to fix it to where the Bureau doesn't have to conduct a meeting every week or month or whatever, like you and Derek were saying, and I was just trying.
Right.
Because that's what we do right now. You know, they don't automatically schedule a scheduled meeting if no one on the normal nomination call, if there's not a rep or an alternate. When that's over, if someone wants to run, they need to either, send an email to Christy or Sally or somebody and request, hey, we need to set up a nomination call. I intend to run for,
So,
Exactly. Hey,
Chair,
hold on just a second. Tom, are you on here? Neil? I need to step away for a minute. So I just wanted to let you know.
Okay.
I'll be back.
Mr. Vice Chair, I do like Madam Vice Chair.
Whatever you want to call me.
What about this? Special elections are triggered in one of two ways. One, a representative or alternate seat is vacated, or two, a representative alternate is not nominated in a regular election nominating meeting, period. And then the second sentence would be, a special election has to be requested by an operator. And then the special election shall be conducted in the following manner. So then that puts in there that it still has to be requested.
I've went round and round with this and offered several different suggestions, so anybody else feel free to respond to Christy's question.
I think that's good.
Okay, so Derek, you're satisfied with those changes?
Yeah, I think that simplifies it. The only thing I would add is up in C where, up in B, capital B, in B5 it says if more than one candidate is nominated, then, or if in 4 it says if only one candidate is nominated. I would add 6. If there is no nomination, then there shall be a special election, and that takes you down to what Christy just said. The same as if a seat's vacated, that also gets you a special election, and that's stated in the rule above as well. And that takes you down to D, where the special election is explained how it occurs. So yeah, I think that's perfect.
Okay, Christy, do you think we could have that written out in its final iteration for the next meeting, and then we could discuss it again and possibly vote on it?
So I'm confused by what I'm putting into B4-5, because again, I think what Derek has just said is that if no one is nominated in the special, that it'll automatically, or in the regular, it automatically triggers a special election. But even then, I think it needs to be requested. I think we're fine with D. With a special election, no matter what, has to be requested.
Derek?
Go ahead, Derek.
Yeah, that's correct. I mean, up in B, capital B section, You're just saying, if this happens, then there's a special election. Then down in D, you're saying, here's how you do a special election. First of all, it has to be requested by an operator. Second of all, you do blah, blah, that's all that language is for. So that when somebody's looking at what happens, they don't have to go down to D to see that there's a need for a special election. They see the need for the special election where it occurs. Nobody got nominated. No operator got nominated. The same as when it talks about if a seat's vacated. It's stated right there when it says a seat is vacated, therefore there needs to be a special election. Then you go down to D and see, well, a special election is this, and it has to be requested by an operator. It has to occur within, and any operator is eligible to be nominated, and blah blah blah, et cetera, et cetera.
Christy, did that clear up the direction I think a few of us were trying to head?
So if back in B, it says the committee representatives and alternates representatives shall be elected as follow, and it talks about the elections. An operator must be present in this meeting to participate. 4, if only one candidate is nominated in a district, that operator shall be declared a winner by acclamation. Then maybe I put another one that says if no one is nominated, that may, someone may request a special election. Is that what you want me to say?
Derek, before you respond to that, just a little bit of food for thought before you give Christy some language. Are we going to cover alternate in this section as well? And if you have something to respond to her, feel free. My thoughts on it are, the way we currently do it is if no one is nominated, then anybody can request a special election if one person is nominated, whether it be from inside or outside the area. So I think that the section you just read would move on to apply to the requested special nomination meeting. As far as how an alternate, if there was only one person who showed up to nominate themselves, how we would then elect an alternate is still a little bit unclear from this draft language.
Derek?
Anybody have? Go ahead, Derek.
Yeah, I mean the statement there is that if after a nomination call in a regular election, there's a vacancy because somebody wasn't nominated, you fill it by a special election. That's the point of it. That's all it has to say. And it doesn't have to say it there. I think it makes it easier to say it there and then explain how it occurs in D, because that's the purpose of D, is to explain how you do a special election.
So I hear you, Derek, but I still think we're covered in D. I think it says D is special election.
That's fine.
And I think it's covered. I think it's covered.
Yep. That's good. That's good.
Okay, and so what are the other issues? Because again, I know that we talked about 8 and then it was back down to 7. I agree that I thought we all agreed back to 7. And one of the things that Annette said to me the other day is, I do need to go back and change. She wants that the Toledo to go back to the, I think, odd number.
Mr. Vice.
Well, yeah, kind of like exactly what it is right now, not to change the odd and even, to make it exactly the way it is right now if we continue it at 7, which I thought everyone agreed to.
Okay, Christy, John's got one, and then when John's done, I'd like Scott to also talk about this. Go ahead, John.
So, thank you. I talked to Annette a couple of days ago about that as well, and I was not under the impression we had gone back to 7, but since that may affect me, I personally don't care either way, whether it's 7 or 8, as long as, I really don't think it's going to make that much difference.
Hey, Scott, are you still on the call? Because I know that you had a very strong opinion about this when we. What's your feeling on 7 versus 8?
I mean, the reason why I brought up
8 in the beginning was just the fact that it was overwhelming for the Columbus rep and alternate at the time. I mean, we can discuss, you know, districts and proportioning and all that at a later time. If we want to go back to 7 for right now, I don't have an objection to it. You know, my main concern is I just want to make sure that all of the rep and alternate positions are filled.
Okay, so how about, does everybody agree that let's just keep things simple? Let's just go back to 7 and let's go with the same election dates as in our current rule package. We'll keep the number of districts and the elections for those districts as they are. And then next year we can discuss what those districts should encompass, the zoning and all that for them. Or actually not next year, this coming summer, so.
Mr. Vice Chair, thank you. I wanted to let you know I was back.
Oh, wait a minute, you weren't recognized, but how could you?
Well, I'm hoping everybody solved all the woes of the program while I was gone. And
I don't, Madam Chair, we pretty much, Derek and Christy got some language together. I think Christy's, we kind of understand where we're trying to go with that. I think Christy's going to have something for us maybe to take another look at the next meeting and perhaps vote on.
Okay.
And we kind of decided that the push for an 8th district isn't really necessary right now. We should leave it at 7 with the same election dates as we had in our current rules package. And now you're all caught up to date.
Sounds good. And the reason why that came back up, because I did get a couple questions from members that said, did we decide on this for sure? So I know we had talked about it, and I know there was some confusion as to whether, you know, we actually came down on one side or the other. So that's good. Just sticking with the 7 and moving everything
and Madam
back.
Chair, just so that we don't lose it in the order of things, we should also look at that language as rewritten at the next meeting and also vote on that change because we had approved 8.
Exactly. Okay.
So, Madam Chair and Tom, with all due respect, like I waiting for the next meeting, we needed to move on these beforehand, and we really want to put this in the process because it's going to take a long time for the process. So what can we do to, like, I can send this out today. What if this is the last thing? And even if it's, you know, Greg, I don't know if you have any thoughts, like.
Hold on, Madam Chair, may I, or Christy, may I?
Yeah.
Yeah, go ahead, Tom.
I have a suggestion that might simplify things. If you can read us the draft that you have right now, then I would consider making a motion to accept the draft as read. And that would let you guys go forward. Does everybody on the committee agree that that would be acceptable as long as we get the printed copy of what she reads?
I'm good with that.
I'm fine with that.
Christy, does that solve the problem? We don't have to put it off till the next meeting?
Yeah, it does. I'm just fixing the Toledo back into the odd numbers. Okay, so the rule as written right now, I can read it.
Can we wait on that, please?
John?
I mean, are we finished? There's other things to discuss in Rule 12, isn't there?
I know you had a question you wanted to bring up too. So
yeah,
we might as well.
I apologize for interrupting.
No, that's okay.
I apologize for interrupting, but that's why I did it. So,
no,
Madam Chair, at the very end of the room, I don't remember what letter it's at. We talk about us having nothing to do with any of the employment issues, and I generally totally agree with that, except that I think if the employment issues affect our budget and how much we're spending for employment, then we should be involved in that.
So that was discussed at great length, and again, we can't agree to that. We had already said that employment decisions cannot be a part of that. We've gone back and forth on that.
I think we did try to fix it with putting the budget in the list of active participation things. Isn't that where we kind
Yeah.
of all came down as a kind of a compromise for that? Because the staff, the budget part of the staff would be included in that. And
Okay. As long as we can discuss it somewhere, I'm good with it.
okay, good. Yeah, it's in the list. I believe we put budget in the list. I don't remember there's a whole list of things that we actively participate on, and one of those things now are the budget.
Madam Chair, I just want to make sure, for example, if they, for whatever reason, need to hire more people, that we agree with it, since that greatly affects our spending power and our ability to do other things in the future.
And
that's the only reason I brought it up.
Yep, you're absolutely right. Yes, Tom.
Just for purposes of clarification for future anythings, I want to address that as well. Greg offered some compromises to us when we raised that objection about staff, and they said we absolutely can't have input on staff. And so even the creation of positions and all that, they didn't want us to have input on. However, the amount of dollars spent on staff, I think was where we came down. We will have input on how much of our budget staffing consumes. We just will not have input on who's hired and for what position. And I think I'm making that clear. If I'm speaking out of turn, please clear it up now, because this is a very important topic that we're going to be revisiting for years to come.
No, that's how I understand it as well.
Okay. Good.
And that was our main concern, was the budgetary parts of things, how much money was being spent. So, yes, Frank.
Madam Chair, I will add to I don't know if I want to call it a different perspective, but what Tom was saying, and yes, we do need to be involved in the budget. And you and I both have done this. I know in the past we have been in on interview panels when certain people, I think probably you and I, when Adam Kiefer was interviewed and hired, we are part of that process, being on the committee. And there's been a couple of other people that were, so I don't know if they're saying we're no longer allowed to participate in things like that or what. That's a little concerning, though, or very concerning, however you want to say it. But anyway, thank you.
So, Madam Chair, Madam Chair,
I'll withdraw my request.
That's a courtesy, and again, we're willing to do that in the future for the exempt positions. We're not allowed to do that for the union positions because of the laws and the rules. And I don't think legally we can put that into a rule, but we will absolutely extend that same courtesy that it's like the second interview.
Okay. All right. So, Christy, you got Rule 12 ready? If everybody's concerns were okay. Addressed.
The OVRC is fully representative of all blind licensees issued licenses by BSBI pursuant to Chapter 3304.34 of the revised code. 1. The OVRC is comprised of 7 representative districts in Ohio. 1A. The OVRC shall vote on the district boundaries at the meeting preceding October 1st. AB. District shall be centered around Columbus, Zanesville, Akron, Canton, Cleveland, Toledo, Cincinnati, and Dayton. 2. The OVRC shall be composed of 7 licensed operators who are elected by the operators assigned to the same electoral district. A. An operator's electoral district shall be determined by their principal place of business. Each representative shall represent all operators assigned to the electoral district. An alternate representative shall be elected for each electoral district. A representative and an alternate representative from each district shall be elected for a 2-year term commencing on July 1st of the year of their election. If a representative is absent from a meeting, the alternate representative shall participate in that meeting with the full rights of the representative. If a representative is unable to complete a term, is recalled, ceases to be an operator, or moves from that electoral district, the alternate representative shall complete the representative's term. If an alternate representative is unable to complete the term, ceases to be an operator, is recalled, or moves from the electoral district or assumes the representative's position, a new alternate representative shall be elected to complete the original alternate representative term. No special election for an alternate representative shall occur if there are 90 days or less remaining in the term at the time of any vacancy. The committee representatives and alternate representatives shall be elected as follows. BE shall schedule and conduct a nominating meeting on or before April 1st of each year in which the representatives and alternate representatives are to be elected. Elections shall be held for OVRC representatives and alternate representatives in Akron, Canton, Cleveland, and Cincinnati districts in even-numbered years, and in Zanesville, Toledo, Dayton, and Fort Columbus districts in odd-numbered years. An operator must be present at this meeting or participate through telecommunication options to be nominated as a representative or alternate representative unless prior approval is granted by BE. Only operators operating the facility through a signed BOA may nominate and vote, and only for the representative and alternate representative for the operator's own electoral district. If only one candidate is nominated in the district, that operator shall be declared the winner by acclamation. If more than one candidate is nominated in the district, BE shall prepare a ballot listing all the candidates, and BE shall mail a copy to each operator in the area within 5 business days of the nominating meeting. The ballot shall be counted only if it is marked for one candidate and received by BE on or before the 15th business day from the date the ballot was distributed by BE. All eligible ballots shall be counted with an OVRC representative present after this deadline has passed. The candidate receiving the most votes shall be the representative, and the candidate receiving the next greatest number of votes shall be the alternate representative. In case of a tie, the representative shall be the operator with the most seniority, and the alternate representative shall be the operator who has the next greatest amount of seniority. BE shall provide the results of the election to each licensee within the electoral district within 5 business days of counting the ballot. The operators of an established electoral district may petition OVRC to recall the current elected representative or alternate representative for misconduct or neglect of duty. The petition must be approved by 51% of all eligible operators of the given electoral district and shall clearly specify the charges brought against the elected representative or alternate representative. OVRC shall determine if just cause does exist for the recall ballot and direct BE to send a recall ballot to the eligible operators if it determines just cause does exist. 2/3 of the eligible voting operators of a given electoral district are required to return a ballot with an affirmative vote to recall a representative or alternate representative. The results of the ballot shall be effective immediately. Special elections are triggered in one of 2 ways. 1, a representative or alternate seat is vacated, or 2, a representative or alternate is not nominated in a regular election nomination meeting. The special election needs to be requested by an operator. The special election shall be conducted in the following manner. BE shall conduct a nominating meeting as soon as is reasonably possible. An operator must be present at this meeting or participate through telecommunication option to be nominated as a representative or alternate representative unless prior approval was granted by BE. Only operators operating a facility through a signed BOA may nominate and vote. Unlike a regular election, any operator under a BOA may nominate themselves or others that are not in the electoral district that is vacant. If only one candidate is nominated in a district, that operator shall be declared declared the winner by acclamation. If only one candidate is nominated in, should it say the vacant district, in the vacant district, that operator shall be declared the winner by acclamation? I think that's what it should say. Vacant district. So that's saying, like, if we do a special nomination, I'm pausing, and a person does come forward from that district, then they're automatically by acclamation. It doesn't matter if an outside person now wants to be it. That's what you guys said, that the person that now comes forward, if they're the only ones in that district, they're the winner. Correct?
Yeah. Yeah.
You can agree? Okay.
Madam Chair, I thought you covered that below that.
Madam Chair.
I thought you covered, hold on, please. I thought you.
No, can you please hold on a second, John?
I thought you said John.
We're going to
I'm
be
sorry.
voting on whether or not to accept this, so we shouldn't have any discussion until she's done reading it.
If the nomination includes candidates within the electoral district and candidates from outside electoral district, the ballot should only include the internal electoral district candidates. That clears it up. Only operators in the electoral district with the vacancy are permitted to vote in the special election. If there are two candidates nominated, and one is within the electoral district and one is from outside the district, the internal candidate becomes the representative and the outside candidate becomes the alternate. If more than one candidate is nominated in the district, BE shall prepare a ballot listing all the internal district candidates and shall distribute a copy to each operator in the area within 5 business days of the date of the nominating meeting. The ballot shall be counted only if it is marked for one candidate and received on or before the 15th business day from the date the ballot was distributed by BE. All eligible ballots shall be counted with an OVRC representative present after the deadline has passed. In the case of a tie, the declared winner shall be the candidate with the most seniority. Elections may be conducted electronically if mutually agreed upon by OVRC and BE. The OVRC shall establish bylaws outlining how meetings shall be conducted and how officers will be elected and will file the bylaws within BE within 1 week of adoption. OVRC chairperson or designee shall prepare an agenda of topics to be discussed by the OVRC at each meeting and communicate to BE the written recommendations of the OVRC within 15 business days following such meeting. These recommendations shall be considered by BE before any decisions are made, except in the situations requiring the immediate action of the BSBI director. The full OVRC committee shall receive and transmit the state licensing agency grievances at the request of blind vendors and serve as advocates for such vendors in connection with such grievances, participate with BE in developing training programs, and sponsor, with the assistance of BE, meetings for licensees. At the meeting immediately preceding October 1st of each year, BE will actively participate with OVRC and, contingent on the availability of BE funds, shall determine for the next federal fiscal year the amount of co-payment per service call, payments assuring a fair minimum of return pursuant to 34 CFR 395 in effect on the effective date of this rule, benefit payments, and rates of reimbursement for actual and necessary expenses for OVRC representatives and alternate representatives to attend regular meetings of the OVRC and any other official duties performed on behalf of the OVRC. Reimbursement for expenses incurred for attending special meetings is prohibited. The BSBI director shall meet with the committee at least twice each federal fiscal year. Special meetings of the committee shall be convened within 10 business days of the written request of the majority of its members or on the written request of the BSBI director. Committee members shall bear the cost of their expense related to special meetings. BE shall bear the cost of actual and necessary expenses of committee members for attendance at regular meetings. OVRC shall schedule all regular meetings, including dates and times in July of each year. Any OVRC meeting held outside of this schedule shall not be considered a regular meeting. The OVRC shall actively participate with BSCI in major administrative decisions and policy and program developed with respect to BE. Such participation includes, but is not limited to, decisions concerning contracts with BE vendors and suppliers, purchases involving new or existing facilities that are $50,000 or more, the creation of or changes to forms operators are required to complete and or sign, changes to reporting requirements of operators, settlement agreements being considered by BE, extension of TVOA beyond 6 months, reconfiguration of vacant facility prior to posting, known proposals that could cause major reduction in funding for the BE program, known proposals to amend statutes, administrative rules, or written policies or procedures affecting licensees, disputes with grantors where the grantor has indicated the loss of a site or facility, BE budget, and as otherwise required in Chapter 3304-121 of the Ohio Administrative Code. BE shall provide the OVRC members information, including but not limited to documents or other material necessary to understand the issues that require active participation 4 business days before the next OVRC meeting, or if the issue arises less than 4 days before the next OVRC meeting, then with as much advance notice as reasonably possible. OVRC shall provide the BSCI director information including, but not limited to, documents and other material necessary to understand the issues 4 business days before the next OVRC meeting, or if the issue arises less than 4 days before the next OVRC meeting with as much advance notice as reasonably possible. BE shall not take any action on a matter requiring active participation of OVRC without first securing active participation of OVRC, except BE may take action prior to securing active participation of OVRC if an emergency occurs emergency occur in the discretion of the BSB director, tongue-tied. In cases of emergency, the BSBI director shall make every effort to consult with OVRC chair or vice chair prior to taking action, and shall, when such an emergency has abated, provide to OVRC chair a written description of the emergency and the action taken. And BE may take action on issues requiring active participation if OVRC does not respond within a reasonable time. The OVRC shall not actively participate in decision-making processes regarding OOD personnel, personnel policies, or personnel administration. BE may invite the OVRC to attend meetings with third parties concerning BE issues, programs, and policies, and all meetings at which decisions will or may be made concerning any matter that would require the active participation of OVRC. Nothing in this rule prohibits the BSBI director from administering the program and making any and all ordinary decisions regarding the administration of the program.
Okay.
Madam Chair, as a point of order, because we're going to be voting on exactly what she just read, I'd like to make a motion that we accept the draft rule 12 as read by the program manager, and then we can have some discussion so that we're clear.
Is there a second?
I'll second that.
Okay, thanks, Larry. John, I know you had something.
I thought she was asking a question. I do apologize. I thought you said John and not Tom earlier.
Oh, okay.
That's why I was being rude, because I thought he interrupted me.
Oh, no, that's
so
okay.
I'm really sorry about that.
Okay.
No, if you had a point though, John, I would like us to give you that.
She clarified my point. I thought she was asking if we were clear with what she was writing, and I thought she stopped and asked that question, and I was trying to answer that question. That's all that happened,
Okay.
basically.
Okay.
So sorry about that.
That's okay. All right. Is there any discussion on the motion? All right, then we'll call for the vote. Tom?
Yes.
Larry?
Yes.
Scott?
Yes.
Frank?
Yes.
Jim?
Yes.
And Doug? Doug, if you're muted if you're still here. Yeah, I don't know if we may have lost Doug. John?
Yes.
Okay. Doug
Madam
passed.
Chair.
Oh, yes, Tom.
Can we have the program manager read the entire rule package?
Yeah,
I'm just being sarcastic.
Yeah,
That
go
was
for
going
it.
On, and I felt bad for asking her to read that like that. That was a lot of reading, and I appreciate it.
I was going to say when she was done, I was going to say, Christy, I didn't quite catch that. Could you read it again? And
That was a lot of reading.
Madam Chair,
yes, Doug. Hi.
I hate to be the wet blanket on this thing, but and if it's covered in the rule, I apologize ahead of time. This is a long rule and a lot to take in. But I don't think, what if this scenario, what if two people from an outside district want to be rep in another district? How is that handled in this rule?
It was covered. It would hold an election. It would be an election just like any other election.
Okay, that wasn't clear to me, and I've heard this rule a couple of times, and I've read it for myself a couple of times, and
I believe so. I think that was covered. It said if there's more than one, it would, a ballot would be prepared, and
I thought that was for internal.
No, a ballot would be done.
For outsiders as well as insiders.
Yeah.
Okay.
The only difference is the insider gets the nod. If it's an insider versus an outsider, they get the nod. But if there's,
I was just concerned that what if two people from an outside district want to be nominated?
Right. No, there would be an election.
But it's only a nomination, isn't it?
Yeah, at that point,
They'd
it's
have to
only
have
a nomination.
a special election to be nominated?
Yeah, they could be nominated. Multiple people from the outside the area could be nominated, and then the election would be held just like.
Okay. All right. I just, okay. What?
Okay, any other questions on Rule 12 or? All right, or any other rules? Okay. Does anyone have anything else to bring up today that could not wait until May 21st?
Madam Chair, it's Greg.
Yes, Greg.
I wanted to let everybody know, if everybody hadn't heard, that RSA approved the FRRP plan that was submitted for Ohio. Those are the federal funds that you guys, the work group, came up with the plan on how to distribute. And so we talked with RSA yesterday, and they had a question, and they actually really liked how the group had come up with and how they had done it, and asked if they could share that because other states were struggling with how to figure out how to divide and allocate the funds. And when we asked how long, once it's approved, they didn't really give us a time frame. It has to go to, I don't have the department's name, but it's basically the people who send the money and approve it. And it sounds like they're doing that once a week, at least for now. But as soon as we hear, we will let you guys know when the financial team does the final approval and the funds will be coming. But it's closer than ever because the actual plan has been approved. So
I've been standing out here by my mailbox since yesterday.
Well,
so just wanted to make sure everybody knew and had heard the news.
thank you, Gray. Actually, yeah, that's important. We did kind of bury the lead with that today, so appreciate it.
And Madam Chair, I'd just like to, if I could, briefly. The Bureau accepted, the committee, or the work group did a fantastic job putting together a workable plan from a very, very difficult situation. And the Bureau accepted it with no modifications. They moved very fast putting this in. And I just want to say a thank you to you guys. We're all grateful. We appreciate all of your efforts.
Absolutely. And one other nod needs to be made to the Bureau with that. The rules that RSA put out did allow SLAs to take some of the money to keep for themselves, the program, not for themselves personally, to cover administrative cost. And here in Ohio, that was never brought up. It was never discussed. The Bureau did not ask for anything like that, and that's very much appreciated. So all the dollars we're getting is going to go to the operators, and that should be mentioned because there are some states who did elect to take that money, and some of them are trying to take quite a bit of that money, and that should be acknowledged and appreciated as well.
Well, thank you. We appreciate it.
Okay,
anything else? All right, then
Madam Chair, will we be addressing at the May 21st meeting? I assume we may have the discussion about inventory in that meeting, about the inventory losses and the decisions that revolve around that.
Absolutely. Yes.
Madam Chair.
Yes, Tom.
She's probably doing it anyway, but just to make it official, Christy, can you please send out to all of the committee members the exact copy that you just read to all of us?
Sure.
Thank you.
Sounds good. Okay, anything else? All right, then we will adjourn.